broken baker, where crimes are baked in every show. Mysteries rise and truth unfolding. Ready, set, it's time to go. We say it's time to go. Whistling truth, battering news, mixing stories, solving the lies. In this kitchen, secrets are broken, with a spark in our eyes. In the broken baker's kitchen, the secrets crumble like sunrise. We'll sift through clues to find the news, with a spark in our eyes. In broken rise, broken rise. Welcome to the broken baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any of you may be. Sorry we are a little late, but Jamie had disturbing news from her peace trip to Uganda. Didn't work out quite as she wanted to, but she might be leaving again next week to make sure that there will be peace in our time.
You know it.
Thank you, Jamie.
I'm keeping the
world
peace, guys.
Depends on you.
It really does, doesn't it?
And beautiful eyebrows. So I say go bring peace everywhere.
Hey, Julie from Newfoundland. And Jedi Jess already donating to the swear jar because she has a potty mouth. Probably a good idea.
I know I need to go get my own jar and just start putting money in today because y'all, I don't know if even the brain slug was going to be able to help me with Owen's opening. I may not survive it.
It's going to be fun. And just a side note, Mo's hair does look nice today, doesn't it?
Oh, thank you.
I was just like, I like that.
Well,
Jamie, I was
also took
thinking
a
of you.
shower.
I was thinking of you, Jamie, for today's stream snacks.
And?
Ooh.
Oh. What is that?
They're double stuffed. I don't like double stuffed Oreos, but for Jamie, I do anything.
Spooky Oreos.
Hey, Bob, one up.
Oreos are awesome.
I love Halloween Oreos.
But more important
Halloween and Christmas Oreos taste different than any other Oreos, I'll say. Zip it.
More important than Jamie's potty mouth. Just potty mouth. She has made bingo cards for opening statements. How it work, I don't know. But there's a link. You can go and download a bingo card and play along. You have to do something. I'm backpedaling fast to try and wait for her to write some kind of description somewhere so I can read that loud.
I was gonna say I have no idea how they work either.
I'm technology. I'm not the woman to ask. Crafty stuff. I'm also not the woman to ask because I will just tell you buy it.
Yeah, that's why we have Temu, so we can get all the cancer and the Chinese kids can get a job. Hey. I did earlier in chat, but only, well, Jamie was sitting here and talking about how nice Uganda is this time of year.
All these places I've been, it's amazing.
Never leaving your house too.
Yeah.
If you would like to play bingo doing opening statements, please click the link I shared. It will assign you a virtual bingo card. As the words are said by the attorneys in opening, mark them off. If you get a bingo, type bingo in chat and your card number. It'll be a number 001 to 100. Example, bingo 001. This will help us confirm if you have bingo. Most importantly, have fun. There's no prizes other than the prize of being able to crown yourself MOBA bingo winner of openings. If I had known, of course, I would have tried to find a little Lego pack or something so we could ship to you. Sadly, talking about Lego shipments, I can see a few of them have been picked up. I know the cup has arrived in Ohio. The books have arrived in Scotland. I think some of the candies have been delivered, but some of them says address wrong. So I'm hoping that you will get them. I filled it out the way that it looked like it was supposed to be filled out, so I hope you get it. Or else some postal worker is getting a lot of candy and maybe diabetes.
And good morning, Jamie and Baker. Sorry, I kind of rambled in here. I got a bit ranty. Sometimes the newsy news can do that to me.
Yes, good morning, Mo. It's Sarah Boone Day. We've been waiting for this all our lives.
And Iris saying, for swear in an inappropriate job, but that's Marissa's fault because she said DP, dear diary. Always blame Marissa.
Oh, Iris, I love it. Dear diary. She knows I think that's the funniest thing. Dear diary.
Can't do
I
bingo
miss that
and
bush.
chat.
I miss that bush. And my doctor.
I might put the brows of justice on. I plan to be brows of justice today, but I need to budget my time a little bit better. It's not my best thing.
PMSL at one of my bingo squares. Feel like Zach is responsible. If you can't blame Marissa, blame Zach. Hey, Countess Inferno. Hey, Wolfie. And Tammy. Becca Lynn. Oh, been a second. And Roxanne. Where's your wig, Mo? On her head.
It was a non-wig day. You know what? The fact that the kids got to their schools and had a sack lunch and were appropriately climately dressed was a win this morning.
Did you go out in the world with that wig on yesterday?
Yes, I did. Okay. The funny thing is that their school has to look in on me and they're like, okay, it is you, because it'll be me and I forget that I have the wig and they're like, what are you doing? And I've told them I stream, but maybe not as ridiculous, because they're like, what? Who are you? And I was like, no, it is me. I just look like this chick who's insane right now, which I did say.
Oh my God, I'm just picturing that in the school pickup line, just that beautiful wig you were wearing yesterday.
Oh, they just don't even ask questions anymore.
No, I wouldn't.
Thank you, Trout TV, and good luck to you as well. And thank you for letting us steal your coverage yesterday. I have a feeling I would be dumber being close to her defense team. Which candy shipments has the wrong address? Well, the funny thing is I can trace what state it's going through, but because for your privacy, I can't follow which name I sent it to. So they tried to deliver something in SC, South Carolina, or maybe Southern California. Something to CA, that's California, might be delayed because the address isn't complete, which I don't understand. But the one in South Carolina, they tried to deliver. They will notify when it's somewhere. Then there's another one they tried to deliver in Ohio that will be at a pickup spot. Then I have one going to Ontario. It doesn't say anything is wrong with that one. the one going to New South Wales, that's for Melissa Jane, and one going to NL, which I don't know where is.
I don't know what ML is.
NL. N, like in
Oh,
night.
NL?
No, night is with a K. No, that's a knight.
Oh my God.
you know, I didn't even catch that. I was like, you're correct, but I'm a terrible speller. I think that those, I blame the Germans because we are a Germanic-based language for English. What is up? Night should just start with an N. Can we all agree? This is a trick. And especially that I before E except after C, except for these 70 billion other words that don't do that. Yes, 7-year-old Mo is still bitter and angry.
And Danity got fingering on her bingo card.
Fingering?
Hey, Rolling Stone. You're staying late for all the shenanigans. Well, to start with, we'll have a Richardson hearing. So that's going to be a little boring.
What's the defense going to say? What's the over-under on, I've only had 45 days to figure this case out and learned how to lawyer. I mean, that's what I'm guessing it's going to be.
Yeah, it's going to be something like that. But we had no time to plan a voir dire of this witness. But it's your witness. So, not stealing, it's education. No, stealing is the highest form of flattery. Isn't that what you say? All right in California if you keep it under 750. I'm so far behind. Sue didn't win anything, so it's not her. Salty Sue.
Well, that's what I was thinking when you said South Carolina. I was like, that's the only person I know that lives in South Carolina.
Yeah, maybe I wrote it wrong. on a scale from 1 to 10, how excited are we? I'm more nervous because I can see this going absolutely wrong. This can turn into the worst case ever because the prosecutor can just put on witness after witness after witness after witness with nonsensical, I don't know if that's a word, evidence just to show I have evidence, like we saw in the Karen Reed case. And the defense team can quit in the middle of it. All of them gets COVID Monday.
This is what I foresee happening. I foresee that the state is going to very much narrow down its case. I mean, he already did that mini opening statement where, he basically narrated the video. That's all they need. Let's not bring extraneous stuff in. Let's get Brian Boone. Let's get the, state pathologist. Let's get, a couple of the first responders to explain how they found him, that kind of thing. And then let's get it done. Make what the defense lawyers, if I were the strategery person on the state, I would greatly reduce my case to what I needed to complete all the elements and give them less time to prepare. Because right now they're like, I'll get it to you February,
Yeah.
I'm a Sagittarius. I can't work when Mars is in when retrograde, that kind of thing.
Yeah, and again, emails, what? Who got them those? It's not a real thing, is it? He had to have written copies last night. A Richardson hearing is to, it's the same as a voir dire. It's to figure out the Richardson hearing is the same as a Brady hearing. It's to find out if they withhold evidence from the other side. This time it's the defense. Did they withhold crucial evidence from the state? It's we talked about it yesterday, this morning for most of us, in the Aiden Carney case, where they still haven't turned over evidence they produced for themselves in November last year. They have an obligation to turn over every piece of evidence, even exculpatory evidence. Sometimes they use that to bury, most of the time it's the state, they will bury the defense in tons of paper because we have a obligation to give you all the evidence, but all of a sudden they want to put in some medical notes that they couldn't really confirm, and they gave them 550 pages and didn't really want to use them, but maybe want to use them and could perhaps use them. So it's to figure out what, if any, evidentiary value do it have, and if it has evidentiary value, should it have been produced earlier? So that's a Richardson. It's a Brady violation hearing. I got DV on my bingo card, but not DP. Disappointed.
I even went out and got Dr. Pepper Zero.
Oh my God, I got the cherry. I love it.
Oh, I like that. I have.
Well, I figure it is Friday, so if I just save a little, I can put some vodka or water in it when we stop, to have a true Sarah Boone mixology class.
Yeah.
Just stay safe. And the link I was talking about before, maybe if Jess can share it again, I can pin it in the top.
The bingo link?
The bingo link. Good
she has
morning,
it. It's in the chat.
Yeah, it's in the chat, but I have to find it, Jamie. I don't know.
No, she just put it in there like not too long ago. But
have you streamed with me before?
You stay like 50 yards behind, so yeah.
It's because I like to talk to people. I don't know why you hate our audience, Jamie. Sammy spills the tea. Thank you so much. Good morning, my favorite trio and chat.
Yeah. He did say he had stuff at 8:30. So
yeah, the other days he has been doing stuff in the morning, having some hearings. But he did tell the jury to be there at 9.
Mm-hmm.
So the Richardson hearing can't be that long. Bingo cards are now in top of chat.
And you guys, if you are in my chat, you can hop on over to Baker's chat. Let me pin a doodaddy, because I can do that, I promise. Or if one of my...
Just heard in your chat as well.
Oh, she is a mod. Thank you. How do you stream? Well, with the grace of my mods, because I don't know how to do anything.
And I think, just to say it again, get the card, and then she said you'll get a number.
Yeah, there will be a number on the card.
Yeah.
So
and that's what you'll put bingo in the chat with the number once you actually get bingo.
So if you want to participate, no prizes today. If it's a success, I will buy a little something. Maybe some of Panilla's favorite candy. A little spunk. Maybe something else.
I love your candy names. I just love them. Atomic duck poo and snot bubbles or whatever it is. I just love your candy names. Now you try to hide licorice and salt in all of them. I do not approve. But
Jamie loves that we do that.
I am in love now. I hated it when I first tried it, but ooh, it grew on me.
I am going
they
to
have really
be
good
unpopular.
chocolate too, though. I will say.
The chocolate is fine unless they trick you and it's like, oh, it's chocolate, and then there's a licorice bomb in the middle. And I'm like, the hell is wrong? I thought this was a melted milk ball. I thought this was a Whopper, a high class one.
It's actually yesterday when I got off stream and I was like, I need a little snack because I hadn't been snacking, even though I had all the snacks ready for the stream. So I had a licorice ice cream. Oh, that was good.
I don't understand. I'd have to try it. But it does not sound good at all.
It's good. It's vanilla cream with just instead of a chocolate coating, you have a slight licorice coating. It's good. Bingo rules, please. I've been MIA for way too long. Well, it's the first time we're doing Lego on the stream, so hopefully it helps. I tried to do it, and I said nope, and then Jess said, "Old man, do you know the internets?"
Old man River, let me handle this.
Holy fuck. Cold morning in Charleston, South Carolina. Hate the cold. This morning it was foggy out, and so the dew didn't really evaporate. Molly was so wet when we came home. I had to wipe her down because she was all wet, and she has a little stomach problems. That's not good.
Well, look, now you have 2 people from South Carolina. Welcome.
Yeah, and I still don't know who I sent it to because I threw out my address list.
This is
Yes,
why
Aiden is-
Mr. Mo is
is
like, why don't you throw away any of your little notepads until you have to go through them? It is like a thing of hoarders. I have to touch them and look at them and then remember that I've already done this list so I can throw it away.
Yeah, I have to put it up there next time to check off whenever something arrives. I have to figure out a way to do that. Aiden is going to Jill Daniels' court hearing today. Yeah, that's going to be fun. I hope she goes away because she was trying to attack him, and he's a witness in a case. Oh, that's right. Massachusetts don't use the same laws for everyone. Like licorice taste, that's the only licorice taste there is. Licorice ice cream is the best. See, Panilla likes it.
Well, you and Panilla are one and the same.
Maybe if you're exposed to it as a young child, but I've never been a black liquor. My mom would buy Good and Plenty's and like the bags with only the ugly, hateful black jelly beans in them because she liked them and she knew we wouldn't steal them. To this day, I have never stolen any of her black licorice.
Oh, sorry, Jamie. You fell out.
Oh, really? That's weird. It's weird how
Yeah.
that happens.
Weird.
Weird. After calling me a sweet, you sadly fell off the stream. Mass agrees. Licorice ice cream is great. Hey,
I
Holly
just
Mac.
mean you guys are like, you have the same taste in candies.
Yeah.
Hey, Fred. I guess I can't knock it unless I try it. Jamie was the same way when she got her care package. She was like, "Oh,
Yeah.
it's licorice, all of it." And 2 days later, she was, "I have no more licorice."
I know, I was really sad. I was like, can I get some more, please? That was awesome.
Say "fucky" again. I don't know. What time is court scheduled to start? Sarah with an H, like my sweetheart. I think you'll have to, if I know anything about this case, it's be ready to be late. They haven't been within 20 minutes of scheduled time so far. They are always constantly late. Jury was set to be there 17 minutes ago. Do we get a Molly fix today if needed? Well, if she wants to participate, she isn't feeling all that well today. She hasn't eaten her dinner. She did a lot of poo-pooing when we were outside.
Oh no.
Yes, 1 more month and we could have a baby. Thank you for being a member for 8 months.
Oh, man.
Okay, are we
Hey,
going
hey.
with the gangrene shirt? She already did the pus shirt yesterday, so maybe the bloused green gangrene shirt today?
Yeah, a lime color. It must be Jamie. That's his second favorite sweet.
Yeah, that's me.
Jamie's going to go change her avatar to a little Swedish flag.
Yeah.
Brett, thank you for being a member for 2 months. And Brett, I saw before the show started, said he liked to punch Proctor in the mouth in Minecraft. Of course, he would never do that in. But
I mean, who wouldn't?
Okay, can you explain the rubber ducky thing to me? Because I am so confused. How are those? I mean, if I got a bunch of rubber duckies, I think I'd just be stoked and I'd put them on my wall.
because, as you can see, clearly this is a terroristic threat against people.
Were they filled with C4? Because
No,
other than that,
it's-
they're just fun ducks.
It says
Yes.
free can read.
Well, I know, but I'm just saying. See, I would be the problem. I'd be picking up all the ducks. They'd never see freedom, and I just put them in a pool, in a swimming pool, and I do an OnlyFans like pool thing with all the ducks. Free Karen Reed, and people would pay me to stay, neck deep in the hot tub. Like, no, ma'am, we don't want to see body writing. We swear.
Hey, Jar. The story goes, someone left a rubber ducky outside of D&E Pizza, and they blew it into, this is witness intimidation. This is threats against everyone. And it's a little fun thing. And then it escalated, and now girl got charged with leaving them on a public area outside of D&E Pizza. Bukaki went to her, I can't remember if it's Bukaki, but someone went to her house to interview her about it. And she said, I thought it was just like a thing to support it, like every other thing. I didn't know it was D&E Pizza. Didn't know it had anything to do with it, but I didn't leave it on their premises. Well, can't you see how, yeah, it was Bukaki. Can't you see how people can feel intimidated? And she said, it's a rubber duck. As Robert Duck says. And she's been charged with witness intimidation because Massachusetts had some of the stupidest laws on witness intimidation in the country. If you sneeze and someone who might have been a witness to something once feel like that was a bit of an aggressive sneeze, you might be going to prison. That's the law in Massachusetts. So, but out of that was born I made 3 videos about the rubber ducks attacking Canton.
Well, I watched them and I was like, okay, why is that upsetting? Why is that confusing? Is there, like I said, I thought maybe there were things, stuffed inside the ducks.
No.
For the love of all that is Cheetos and Fritos, what is wrong with people in Massachusetts? And I mean the people running it, not the general people.
Yeah, and all of it comes from, if it walks like a dog and it talks like a dog, it probably is a dog. And that's why but that's why someone said, oh, we should all leave these out somewhere. And I said, no, what they should do, get a permit, of course, get a permit. And if they have like a fire pond or whatever you all call it, or set up a Halloween special little kiddie pool, buy these off of Temu, make sure to burn them after because they're probably cancerous if it's from Temu.
Don't breathe in the smoke either.
No, it'll be burn pits in Iraq. But I don't know. I think a unit price is like 50 cents or something. Then you go there, you sell them for $5 and give the surplus to the Free Can Read Foundation. Just get a permit to do it, and then do this every time one of the officers drives by. Say you can write a FKR and your name on it and put it in the pond. That could be a big go F yourself.
I like it. If they have like a canal, because we do in Indiana, they could have a racing of the Karen Reed ducks.
Well, they have to make sure that every single one of them is accounted for after. That's why I said you shouldn't do that.
Oh.
That's why you put them in a kiddie pool.
Good idea. Better idea from Baker.
I have thought this. I thought this through because someone said, well, we should release them. Yeah, but this is plastic and turtles choke on plastic. I don't know why, but turtles do that. Thank you, Baker. Thank you, Dave. The best Dane ever next to Mass.
Well,
our king is pretty sweet too. Never sit on your rubber ducky in the tub. The ducks are too tiny too. Like the size of a coin. Well, then you can sell more of them. Don't sniff the ducks. Never seen a rubber duck walk before. Well, you've never been to Canton.
It does have the Canton Continuum triangle where phones dial up their own accord, where, the safest way to dispose of your, SIM card is on an army base in pieces.
Why not?
The suitcase is there in a box. Also, there's a huge blown up picture of Sarah with a black eye. Oh, it's to prove that she was being beaten.
Oh, God.
God.
I think we should get the huge sock they put in the lakes around the US and put it right in front of the police station. Duck, duck days. Just get a permit. I don't know if you have to write in your permit how you want to do your demonstration. Just get a think you have something called First Amendment rights, and you have the right to protest. Just put in that you're gonna have a protest and do it somewhere, and if you get a permit, I know that in Canton they will still show up like they did with the Canton 9 and say, nope, the Constitution don't matter to me, son.
You and your Southern accent.
I mean, I do imagine. Okay, Morrissey looks like Boss Hogg to me, so I'm always imagining him just saying, "Darn Aiden," you know, and those Duke boys. That's all I imagine, which is probably not kind.
I think we should refer to it as opening ceremony bingo because it's going to be that entertaining. I'm like my wedding night. I'm afraid we are building it up too much.
Yeah, let's see how it starts.
Yeah, you end up with having to sit there and pin hairpins out of her hair, and the smexy time. Nah, I'm tired.
I will eat one of the Sarah Boone snacks if the attorney says, as you know, we only got this 43 days ago, but we want to fight for Sarah, and she has been abused. Like, if he brings up the fact that they didn't have a lot of time, I will open a Pop-Tart, not because I'm hungry, but because I want to appreciate Sarah Boone.
Love the Dukes. Morrissey ate the chicken palm. Well, it's a mediocre chicken palm. Honey, honey. Mm-hmm. She's going a pink shirt today, Jamie. Oh, Mo. Jamie, as our
look at that.
As our beauty specialist, what are we what are we rating her outfit today?
I like the pink and the black. That's like my favorite combination.
Okay, I would like to lodge a complaint because this heifer has now just let her hair just hang out, so it's a fluffy helmet. I am going to have to wash my daggone wig and fluff it up now, and I find that to be damn ridiculous.
And she just shook it out, and this morning it was like, ooh, I like this.
For those of you who are wanting to play the bingos, link in top of description. This is how it looks. You'll get different words: water, hair, art, alky legs. That's the free one. Ex-wife, dancing with dog, hardware store, and no speaking objections, please. And then you'll just keep track of it. Up here, you have your bingo card ID number. This is bingo card 001. If you get the bingo, put in no prizes other than you get to tell everyone else that you are the best bingoer on the channels.
Mm-hmm.
True. I will say that the pink makes her less sallow. It really, I mean, it brings out the rosiness and kind of maybe a look of health, which for her is probably better than looking jaundice and like she's in the final stages of liver failure.
Mm-hmm. It brings out her liver failure. Oh my god, that's funny.
I want to see what's on those papers with the big round circle.
I know.
Oh, yeah, it's
the picture. Jess was they said it was a blown up picture of her with a black eye.
No, she has a piece of paper with a circle on the back of it.
No, Jess had asked, "What's that blown up picture?"
What? No audio. Have I turned? No, I can hear everything.
I do.
Ma'am, good morning. Can you please state your full
Oh.
name and date of birth for the record for me?
Here we go.
10-10-7-7.
All right. Ms. Boone is seated at council table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth.
I'm a
amended
man,
reciprocal
it's pink.
Discovery exhibit list.
There are
Specifically,
5 colors in a man's
119
world.
pages of records from
True.
Advent Health Winter Park.
Had you
They
said
have
fuchsia,
done
I
that-
would have been confused.
Yeah, they have been swearing her in for everything all the time. I think it's a Florida thing.
That were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them deal with just billings, observations by the medical personnel, so that necessarily apply to the issue of anxiety, as the court indicated. I did include certain pages that discuss depression issues.
Defense.
They were related to anxiety, and then I've identified 4 or 5 other pages that are not anxiety related, that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Look, he goes to the podium every time. You can do that, defense.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages,
It's a line.
The first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter.
Get that in there.
The limit.
Giblets.
It's a central nervous system depressant. We are going to have at least 1 medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe
So
it's
how
super
much booze did
mysterious
she drink
why
that
we are
she's
going
still...
from pages 43, 44, 45, 46.
Well, this is in 2018. It's not related to this.
Okay. Oh, all right. That makes more sense. I was okay.
Yeah, and that's why it's crap, because it's 2 years before the incident that they want to use that to prove she had battered spouse syndrome because she had a depression. Well, she was an alcoholic who just went through a divorce, whose ex-husband will probably be asked if she lost her, if she got depressed when she got her kid, because that will really ingratiate her if they have mothers on the panel. So, and thank you, Marissa, for being a member of Mo for 6 months.
Thank you so much.
Think of the suitcase. Well, it was a bad suitcase. The zipper was broken. The judge has all these people behind him. Are they like interns in orientation or something? I think it's his help. I don't know.
Yeah, they might be clerks. They might be people that pull case law, like say they, the state cites such and such, versus Florida. They can quickly pull that up and say, oh, okay, well, this is what the case synopsis says. I don't think it has anything to do with that, or, maybe. Or just get him, some gummy bears when Sarah's annoying the hell out of him. He's about to rage out.
Calm down. Was she doing drugs? No. She did coke once, but didn't like it, is what Brian said in his interview.
7 and then skipping page 48 and then go.
Jamie,
I missed that
part. You should watch the show. We were covering it with the audio hearings we did last week when you were helping the beluga whale.
Exactly. I was helping the beluga whale, so I didn't get to hear it all.
But we do want page 48 included.
But someone gave her coke at the bar, but she didn't like it.
Page 63.
She asked for a rum and coke, only got coke, and she was like, what the hell is this?
So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111.
Greedy bloke, as always, have a point. You can't just try it once and say you don't like it. It's like no one would eat a salad or greens after that. So it's like Jamie and licorice. She had the same thing with her coke habit. She didn't like it to begin with, but now she's fond of it.
I will have to disprove that. I thought when I was an adult, I would get the superpower of liking salads. Lettuce is still gross.
We don't object to that. So basically, we're asking for pages
not wrong.
26 and 48. to be
I know.
included.
Okay, thank you.
So I refuse to eat it.
The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that.
Again, it's my secretary, it's my legal aid. He has an excuse for not doing his job every time.
That was going to be a question.
And everyone has managers like that. Managers that don't delegate, don't tell you what they need, and then blame it on you. Like, oh, well, it's my secretary. I don't know what the hell she's doing, you know, when he seems like a discombobulated boob and he doesn't know how to delegate.
What are they going through? The evidence, the medical evidence that the defense wanted to put in, that they got told you have to whittle it down. You can't put in 550 pages and 179 pictures.
One of my trips down here, I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
No, we're waiting again. It's the same arguments as yesterday.
Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like to stack the documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Ooh, someone told her to put her suit jacket down.
Finally.
I feel
That's
seen.
because I said that
Just a reference
to
that 81 pages were all marked up by the defense. There's no
live yesterday.
there's no
He
markings.
probably did it.
The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow.
Pixie, get to bed. But thank you for being a member for 11 months. Get ready for your Boone, Bucks, Baker, and Mo. We are going to be millionaires, and I am buying a $50,000 house in South Dakota. It looks nice.
The court's instructions,
I
Due to
am
the
doing
publicity in
nothing
this case,
adult
I
and
will ask for
flying
you
to
to be
Tokyo
removed.
and buying out the Sailor
Does
Moon
everyone
store.
understand? Thank you. You may proceed.
And I realized that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as one, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway.
Sarah Boone, world's most soberest
Continue
woman.
to try and search for that particular page out of
And
119,
non-smoking,
so
yes.
that I may ask that out of the doctrine of completeness and fairness, that it be included. I'm just, at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119-page PDF and you make it word searchable, you just put in the magic word, and it helps the
I'm done with streamers blaming boomers for their own screw-ups. Legal vices can...
Kiss my behind.
calm me...
I think we need brows of justice. I'll go get the other one, but we need some brows of justice today because I have a feeling that Owens is going to hurt my soul. And I'm going to have to go to a therapist and point out on the little like bad touch doll where in the brain he hurt me.
I just love that the judge is having none of it. Vince, yes, maybe. Amy agrees.
the attorney greatly.
But thank you.
So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading on it. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may,
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state. We had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay.
So
with regard to,
laws,
let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent.
Should wear them
willful.
outside.
The court finds that based on the positions provided by the defense that the disclosure was inadvertent. I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they're able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I've seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough. But particularly with what they are seeking to introduce, given the motion to eliminate ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in.
Because this defense team is absolutely the worst. The dog ate the whole. They are already getting into jury instructions, even though we heard them talk about yesterday that we are not getting into jury instructions yet. So they want to put that in there. And he's going to say something about, well, it's boilerplate jury instructions. And now he want to put in pictures that has nothing to do with it. Where are they from? How can you claim it has anything to do with whatever? They are the worst. Anyone who thinks the only thing she's better off with this defense team is I don't have to read 48 pages of her handwriting. She could have done just as good a job because they are horrific or horrible, whatever the word is.
That it would be extremely prejudicial, dangerous.
Well, people also say that cheesecake is good. Some people are liars.
Dangerous.
Baker, I'll have you know I didn't get up the cheese Danish as my Friday treat just for you, because I knew it would offend you.
Which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are evidence of prior threats, prior events of violence.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
Still,
wait a minute, you got the Kinko's for your mega posters, but you didn't get your Federal Express?
Well, the road was
smell
closed.
BS.
The road was closed.
He managed to walk his, old man river behind to get his mega posters of Sarah. Unless he went to Kinko's and one was Federal Express, but amazing he is able to get stuff done when he really, really wants to. Is the court reporter not wearing shoes?
She's not wearing shoes, no.
I give up.
Are you sure? Are they nude shoes?
They're probably nude shoes. I just love how my ADHD brain is like, you're having a serious thought. Is she not wearing shoes?
Well, no, like I was wondering too, and I'm like, are they maybe nude shoes or something? That's weird.
I love these. I need to tell my children no more wire hangers, just once in these.
And Vince, I don't know what has been said on their channels. I didn't watch it. I didn't know it, but no, don't call people names they don't want to. But I don't know. I can't say, but thank you so much. And
Vince, I'm just authentically bad at technology.
Yeah. I think I'm technically Gen Z. And thank you, Jess, for another swear jar contribution.
And Vince
I know what
is
that
always
is about.
welcome over here anyway. So
Yeah, we won't yell boomer at you because I am the boomer on this channel.
Yes, we take that name because doggone it, we're usually muted half the time. We don't even realize it.
And we appreciate all ages and sexes. Well, I appreciate just a little bit of sex. What?
No, I can see it, sir.
And the other one is a reasonable doubt is not a possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge's opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in the circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please?
Why are we fighting over this? These instructions come at the end.
No, he want to use them in opening statements. That's what the fight is about now. He want to tell the jury right now what reasonable doubt means. Remember, everyone, that reasonable doubt, then you must acquit. He want to tell what's self-defense. But that's not his job, because he's there to give an opening statement. He's not there to lecture them on the law. That's for the judge to read to them in the end. And then he can summarize why he believes it's this or that.
Do you remember the, the Trayvon Martin case, Zimmerman? Was it in closing that they had the big board that explained reasonable doubt?
Yes.
Okay, so this is all closing stuff. Okay, I knew the other. Okay, why is he so bass backwards? Sorry, not even 2 hours in.
And he shouldn't be allowed to tell the jury what reasonable doubt means. No, because that's for the jury to find out. But and it will be read during jury instructions. It's not evidence, but you can change them. It's the same. You can't get up there and say, well, Jorge was holding a gun to her head and she was fighting for her life. Because you can't lie. It's not evidence, but you have to talk about the facts of the matter.
Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proof beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons.
Yes, he can say everything he wants about reasonable doubt, but he's going to present this as this is reasonable doubt. And that's a different thing than saying, remember that remember when we talked about reasonable doubt in the Wadir hearing?
I'm not going to allow it.
Judge, I'll have it redone. The arguments.
As long as it, I mean, we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
This is an excerpt from.
No, it's not. He just read it to you. It's not an excerpt.
No, it's what you want reasonable doubt to be. Why is he so confused by when the judge says no?
Because he is like Sarah Boone. I'm going to hold my breath and stamp my feet.
Absolutely nutty.
I like this judge. If you're coloring outside the line,
yeah.
don't put it on paper. Just wave it in there. Yeah, exactly. You go up there and you don't pull up you just talk about reasonable doubt and how much of it there's in this
That
case.
seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways we do it where we give them the law at the very end, you know, and.
No, they don't need a guidance to the law. He's going to read them jury instructions, and then he's going to give them the jury instructions again in the end.
I understand the reason for that, depending on the evidence that comes in, but they're standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility.
Kirks, we are trying to get to opening, but defense is not having it.
Of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
Yeah, and then only bring in.
I think for the record, we should mark them.
4 to 6 of the commandments, and
do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please, Madam Clerk. Yes.
And why is none of so they don't have the? There's a system that the evidence uses. I cannot remember the name of it for the life of me, but they don't have the little numbers, so. It's just ridiculous. Why does he have none of this? Good God, how much does this man spend at Kinko's?
I don't know what Kinko's is, but if it's not a SMEC store, they named it wrong.
You can do it at, like, they just print ginormous stuff for you, like vanity posters or all the things they use in Congress.
I still think it should be a SMEC store. Kinko's is the right name for a SMEC store.
I do think so. You know what? That's it. We're taking Kinko's back. We're making it the kinky store it always should have been. Vote for me for president.
Let's speed this up and get to where anything happens, because this is going to be a cluster muck.
We're not going to get to opening statements till Monday. I hope I'm wrong, but oh my dear giblets, this is.
Well, it's not from FedEx because the road is closed. I actually like demonstratives. I really like demonstratives. I think it brings you closer to the evidence. Either put it on an overhead, but at least show. I think that was a mistake in the Karen Reed case, that they didn't put a demonstrative up showing how the timeline didn't work, and made a demonstrative of the ARCA guy's explanation how she couldn't have hit him with a car. I like demonstratives. I'm a visual learner, so give me all the overheads.
Was that Auntie Bev's, no demonstratives? Because I do think that it was. I like the demonstratives that kind of collate all of the information into an easily understandable infographic. I know the Darrell Brooks case did that to great effect. They had the entire parade route, where victims were, what happened during certain things, and it kind of also integrated a timeline. So those make it a lot easier, especially for complex cases. Oh, Her talking aggressively creeps me out.
Yeah, and why is her hair lighter today than was yesterday? It looks like she had a little spray in summer sun or whatever it's called. Don't they have an Elmo? Isn't that a weird doll?
It's that little doodad that's like a projector that you used to have to sit in trigonometry class and pretend to learn. So it just, pops it up on the doodad.
We didn't have doodads when I went to school. Yeah, but oh, they're talking without the mic again, so we're just gonna keep it going. Why is everyone? I'm being called Naker, Bacon. Yes.
I'm sorry, I have a deeply Midwestern accent, so I say things wrong all the time.
Oh, but people are writing my name wrong. That's Sonin. Thank you, Show Live. Jamie is my beauty consultant, but we can't hear her. We can just hear her tapping. I'm just keeping it going so we can catch up. I think she just watched it. Yeah, but we were talking about yesterday how for a 47-year-old middle-aged woman, she didn't look that great. I love that he called her normal middle-aged woman diseases. She hated that. Do we only get one back of the head camera view? I want to see a face when people are testifying. I bet you they were standing in the jury box with the camera yesterday, so you won't. You will get this shot and then the podium or whatever you call it, the witness box. Because words are hard, Baker, and you get my name wrong all the time. Yeah, I'm sorry I call you Jess. Jemima, I will never do it again before the next time I forget it. So now we are mad about wrong names, Mr. Kettle. I'm not mad about wrong names. I'm just saying it's weird how all of a sudden I'm Mr. Bacon and I'm Mr. Naker. And thank you, Bad Dog. I'll be okay. I'm always okay. Because everything's awesome. Everything's okay. At least I have
Well,
a
at least I
different...
have that in my I have that in my head instead of them talking not in the mic now.
I know. Thanks a lot, Baker.
Any other further argument with regard to the use of those?
Rubia, according to the state, 47 is a middle-aged woman. They read it yesterday and we laughed, and I said, on this channel, that's a young woman. We don't see age the same way as they do in Florida.
Ageism.
True.
Items pre-marked as A through I in opening statement. Mr. Owens. When did you send it, sir? I have not received it.
Of course not.
Oh my gosh, they're trying to float a check like they're floating evidence. They're like, look, I know we need it by so-and-so, and I can get it to you by Tuesday-ish.
I can give it to you now, but can you wait to withdraw till Monday?
State seen a copy of it?
I'm familiar with the case law. I did receive the email.
Not that I ever did that as a young person. That is bad and illegal. Do not float checks.
Separate one. I'll check.
But you always knew. But you always knew the stores that waited 2 days to, kick them over. Just saying.
326 Southern 3rd, 656, 4 Supreme Court 2021, Low v. State 259 Southern 3rd 23, 4 Supreme Court 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy that we're using in a homicide case.
What is at top of the screen? Oh, yeah, my name is on the top of the screen, but people don't read. They just harass.
Which court allowed other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Al-Kagir case, which is the 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record.
So he read a case law saying they weren't allowed to
2018
use
case,
the
Supreme Court of Florida. Again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution.
Yes, because he won't understand why he's bad. Lally chose to do. He didn't choose to do a bad job, but he chose to obfuscate what he was doing by yammering on. This guy is absolutely out of his depth. This is the first case. This is the first time in 6 weeks he's citing case law.
Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound.
It's because he want to use demonstratives in his opening statements that the state objects to because it's incomplete renditions of jury instructions to paint a fake picture of what the law is. And Rubia, I'm 57, need to know if I can still be middle-aged or I'm old now. According to the state, you are at least middle-aged, but thank you so very, very much. It's way too kind. But
I'm glad to see Rubia again. Hi, Rubia.
Yeah. It was so awesome when you came on and explained things to us in the Karen Reed case. So thank you for doing that. I know that's not your jam most of the time, but thanks for, giving us your wisdom. That was awesome.
But again, it was the state who claimed she was middle-aged, and we laughed because we know that hurt her deep in her little soul.
Mm-hmm. Yeah, it's weird to be excited when the Schadenfreude is real.
Where only with slight difference between the victim size and the mannequin's dimensions, there was nothing to suggest the mannequin was altered to resemble the victim. The court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from yours.
It has nothing to do with this case. He was just citing case law where someone was allowed to use a mannequin as a demonstrative because he needs to try to keep his demonstratives in. And I love that he goes further away from the microphone after he just moved up to the microphone. You are whatever you need to be. Yeah, you're as old as you feel. This morning, I felt like I was at least 28.
It does feel weird that they can pull all the spaghetti on the wall. After you hear that video, is anyone going to, and the fact that she, hit him when his hand came out, is anyone going to buy any of this? You can show all the posters, and I think we can all concede that they were toxic for each other, just like, Johnny Depp and Amber Heard. But she does not portray herself as a victim, and this is going to make this insurmountable. Again, she could have maybe said it was an accident, and had they said, kept it to an accident, she should have taken the plea for manslaughter. That's the best you're going to get. I feel like I'm talking to my youngest, most feral.
The actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. We can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much it was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent.
Yep, we
which
have a
resulted in
ruling.
an imminent threat
So,
of great bodily harm or death.
let's follow that,
And
Judge.
We have had that litigation. We have provided the court the most recent test.
It wasn't, the mannequin had nothing to do with this case. He was citing case law, but because he wanders away from the microphone, you just heard the word mannequin.
Testimony regarding the defendant's most recent statements from the two doctors, and that it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly this is A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and we'll be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I included.
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. I don't know.
Okay.
It wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, Judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in. Remember that?
No, what I ruled is that you were able to discuss them, address them in opening. Photographs are
You don't
totally different.
sass brows of
I said
justice.
nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'll talk about self-defense.
I understand.
And prior difficulties. Prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there's going to be evidence of an overt act. And she was facing imminent threat, and she reacted.
Well, they're going
Understood.
to Sarah
Response to
for
Exhibit B.
the truth.
It's her on the back porch with the two dogs.
Judge, not only did he abuse, more stories abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce that they listed as exhibits I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. And he would
Oh, screw you. I mean, I'll pay.
Okay, thank you. All right. The court's prepared to rule at this point in time.
I
Thank
feel
you both
like
for your
she
presentations
did
and your
also.
argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific, some incidences made it happen, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to
Thank you.
play the 2-minute suitcase video to the jury in opening statement.
What?
State.
Why?
Again,
Why?
Baker, you're muted.
You're muted.
You're ranting into silence.
Yeah. They woke up this morning and said, honey, can you get the elephant rifle and the 50 cal? My feet need some aeration. They are going to play the 2-minute video that is going to send her to prison.
Wait, for the...
How are they going to spin it? That's what I am excited about. Oh my
You
God.
can clearly see that she needed to self-defense herself against this person. He was clearly just about to jump her.
I will say it's oddly comforting just to rub your fake eyebrows. Gonna pet my eyebrows when I get stressed now.
But did they wake up this morning and choose stupid?
I don't like. This is where I'm like confused on where you're going with this, Owens, because you want to play that terrible video and what's he gonna say? That's what I'm interested in. Let's hear it. I want to hear it. Let him do it.
Afraid when.
Let him do it.
Clearly
Let him
shows
do
the
it.
need for self-defense.
Yeah, let him play it. I want to hear this. Let's go.
I might need to break out the handlebar mustache for this. There is not enough comforting just with eyebrows. What is going on here?
I'm
And thank you, Jess, for filling up the swear jar today. Let's hear his great argument. The judge was, what? Well, it's a good thing to blow your case on the first day.
Yeah.
I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach eventually.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose, it's good for the gander. I'm not going to allow your photographs, I'm not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
No one wants to see big blown up pictures of Sarah. We all agree. Oh, I want to see how shorty her skirt is, Blondie. Because I'm guessing she's going to have to like put a file over her lap when she's sitting down.
So what does that mean? That means like his whole opening is out the window, right? Because he wanted to play the video. He wanted to use all these pictures. What's he going to say now? He's like, dang it. I worked so hard on this.
I just love that they are sitting there thinking it could be a really good idea to hear a man beg for his life to show how self-defending she was.
Yeah.
Remember that person who said this could be her Jose bias?
Are they trying to throw the case? Are they like, Sarah, we got you the best plea deal ever. We are just going to bury you now.
Yeah, you didn't buy it.
Any reason why we cannot bring our jury this time? State. Defense. All right, let's stand and bring our panel.
Yay!
Oh, thank you.
Finally,
Tiny
we're
baby
getting
Jeep.
going.
Goodness gracious, finally.
And she's going to have that smugly face just.
Just right out the gate.
What
I'll
do you
play
see?
this video.
All right, guys, don't forget your
State, you
bingo
recognize our jury.
cards.
You recognize our jury. Yeah. The party's place for a moment.
Yes, Bullstorm. That's her argument.
After she used a baseball bat on his fingers as he was trying to get
I
out,
want to just confirm
she
before we
was
start this morning that you
scared.
complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confirm you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you approach for a moment?
So someone saw someone.
And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Bet you he farted in the elevator.
Gil, you made it just in time.
Thank you, Broken Baker, for your super chat. You get a ticket or a tag. Unfortunately, my board is covered because Mr. Mo explained to me what measuring and planning before moving stuff is. I'm going to try it. It sounds ridiculous.
I thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way? Did it have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. As for the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J.
Everyone, now opening statement starts, bingo starts. Remember, if you downloaded your bingo single myth top link on my chat, you can go. I don't know if Mo put it up there too. Go get your bingo cards. It's a win list. The only thing you'll get is we'll put a banner on the bottom saying winner of the bingo. But bingo will be doing opening statements. Remember, Alkylex is the free word.
You may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you.
Go back to the microphone.
Zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. Evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. Now, for conscious disregard for whether he lived or died,
Thank you, Shalom.
you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby. That's what I feel like when you cheat on me." Sarah, "Fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:20.
Thank you, Brendan. I haven't checked if I'm red or yellow. I'll handle that later because with Mo
Sorry.
on, you never know.
Pretty much.
3 p.m. There's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is put into this suitcase left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my God. The first thing she does after taking him out, and I believe you would hear a description by the defendant saying, he took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. And the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. normal work day for most people, school day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, they'll co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020.
I'm eating an Oreo because this is annoying.
Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her. Then she finally calls him back instead of calling 911. Being the nice co-parent that he is, he comes over. It's a short drive, 10 minutes. And then she's explaining to him what the heck is going on. He peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check, please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside, though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase, and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in his death, was taken to the 9th District Medical Examiner's office in autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% to be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. Will help her explain confusions and bruises. She'll use words like hematomas. Will help her understand for you all that that means bleeding under the skin and blood. What you expect from a bruise, that's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up. And defendant interacts with the first patrol officer, you will see and hear that body-worn camera. It's more of the same of what we heard on the 911 call.
Lapel mics, $30.
I fell asleep. What happened? A few hours later, the detectives from the homicide unit at Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of the counter that was found at a suitcase by Mr. Torres and giving it to one of their digital forensic examiners who we'll hear from later in the trial. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters. So the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And here's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man, and the defendant
liters
is in the same weight
Good
class.
giblets.
That's a lot.
1.5 liters. That's a double bottle of wine.
Yeah.
Because normally it's 70 centiliters, which would make 1.4 liters if you have 2 of them. So it's more than 2 bottles of wine per person. And again, I don't see George as a big Chardonnay drinker.
No. And if you're going to
Magnum.
drink that much, why not just get a box? I mean, it has a little spigot. You can just lean it on a table. That kind of thing. I'm imagining. I mean, they wouldn't even have to put it in a glass.
Well, at least he drank. Well, I don't know if it's smarter to drink expensive. Yes, that would make that. But normally a bottle is a 70 centiliter. This is a different story than we thought. Late, many trials, watch bingo, catch me up, please. Bingo is just the words they are using. We have just been starting the opening statements because there was a lot of motions before that. And this guy is allergic to microphones. You are now caught up. Other than that one bottle of wine she claimed they were drinking were 2 1.5-liter bottles, which is banana pie cups in American numbers.
Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out.
Brian,
we're still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best.
And thank you for the gifted memberships.
When they started playing hide and seek,
those went to, let's see here before it pops up on me. Lewis Thomas, Shalom D, Nanny Goat, JKD Buck, and Mass. So thank you for joining the Church of Mo. I will get your tickets going. So thank you, Wolfram.
It's not a ton of wine. It's 4 bottles of wine. And I'm saying Mama got her spiked Dr. Pepper too.
She went up to the shower and then got tired of hanging out in the shower and came down. And that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out. We're going to have sex and go to sleep and call it a day. It was a good day.
Ooh.
Would it be a good day to end it that way with Sarah? I know we men are basic, but still, imagine looking into that face while you're slaving away.
To be fair, I mean, Black Widows get action and they usually eat their mates. So I guess, you know, when there's a will, there's a way.
She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music,
Peaceful.
play with the dogs. We drink
Mostly
what we
peaceful.
can afford. We used to be able to afford liquor, but now we can only afford wine.
I need to get a small violin.
That's how that day ends with the police. She goes and sleeps and stays at
Stay at the mic.
house the night of February 24th. What they are doing, and by they I mean the Orange County Sheriff's Office, in part, that's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time.
2 fingers is okay with 2 little fingers.
He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres.
We have a potential bingo. Bingo, bingo. TJ White Bingo, 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 TJ White. I don't know, Jemima, will you be checking it before I put her on the banner as today's bingo near? I don't know how it works. Oh, and we have bingo 054. Bingo 054. All alcohol is so expensive here. You can get cheap liquor, which you would get more hammered off than wine. I don't buy it. But as soon as I have confirmation, I will put the banner of today's Bingoneers.
She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too.
Well, don't do it. I don't have. It's Jemima.
But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself.
Wallstrom had bingo way early. Well,
then she gets to the hide and seek again.
Just come on now.
Again, and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not
is the free word.
To, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event.
You can go for blackout bingo as well. I'm still waiting for confirmation that one line bingo has gone. Blackout bingo will be the next one. And I don't know if we can do a do-over for defense opening. Jemima is Madam Bingo, and I'm waiting for confirmations.
She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall.
TJ White, Becca, and Volstorm all have single line bingo, ingo. Now, who will have blackout bingo? Who will get
Woo!
Sarah Boone? Which one will be the Sarah Boone? And Jess, I don't know, can we redo it for the defense? But I'll put the names in a banner, and then we're gonna see who's gonna say blackout. I think I can say that on YouTube.
Yeah, I don't. Well,
Yeah, why wouldn't you be able to?
I don't know.
Black eye bingo, exactly.
Yeah, that's a good one. Black eye bingo.
We can do blackout, which is full card, and we can start over for defense. There should be a reset button on the cards. Thank you so much. And when he's done, we'll try and explain the rules for bingo again, so everyone can play along.
January
Shuttered Island.
13th.
No, we tend to not make
There's
fun
another
of
heated
George.
discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to.
This girl hasn't done anything sober since 5th grade, so yes, she was drunk texting.
Come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. This is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Well, I participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning,
Thank you, Show Life.
we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met.
Rubia, everyone is talking about that. How? But he was 103 pounds. He was very small. He looked
Yeah, and I think he was
malnourished.
only 5'2" or 5'3". So if he got in the fetal position, he probably could. But it's so the latest story is that he was trying to hide in it, you know, when she caught him because she was upset that he made her stand in the shower.
Yeah.
And that's what took her all off. It's just her story doesn't make sense. And I am praying that this is not going to be a drag, you know, George, but it looks like they are going to just drag this poor man through the mud. And he wasn't perfect.
Yeah.
He had a lot of demons. I'm not negating that he shouldn't lay hands on Sarah. Sarah shouldn't have laid hands on him. But
no, but again,
yeah,
agree. But
it's not.
Don't. And I'd never think it's a good idea to talk bad about the person who can't defend himself, even if it's a self-defense case. We saw that with the Benefield trial where they were trying to put a lot in there that her husband was a bad guy as well. I don't think it works.
Torres, he smashes her phone, punches her. It's the first time in her life she ever been punched. And he made her curl up in a fetal position on her own porch for 4 hours. And she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated for alcohol. This is a man who has serious alcohol problems, and I expect.
I love that it's no longer my keyboard. Sorry, Jamie.
Oh, I didn't realize I was not muted. Sorry.
Oh, no, you're fine. I like the clickety clack, but
Sorry. I had to write a
I wish I could
furious
hear
email.
him.
It's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these dates are at bars, and there's nothing wrong with that. And it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview.
Dave, there's a lot of volume. The problem is this guy, if you can see this podium, that has the active mic. And he likes to talk to the jury because he's presenting the case to the jury and isn't thinking about us.
Bloody ear. A stab wound in the leg, which is perhaps described as sword fighting, playing around in medical. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5.
yes, MLS, where are you?
Manual, version 5. Text revision or something like that. What it is and what they describe it as is kind of a component of post-traumatic stress disorder. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it means these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth.
Atheist, I like him a lot. He is very fair, and he doesn't take crap. I like that. Thank you.
But because there's no, it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You will hear.
Well, let's try smart TV then to see if the
Sounds
audio is
wonderful.
better. Yeah, because I'm getting angry at this.
I
I know it's not for
I
us
like
that they're doing it, but
yeah.
turn up the gain on the microphone.
I do like that he is getting ahead of
Between
a
one of the decedent's brothers and the
ooh.
bloody ear.
Not that much better. Yeah, it's boost.
At her back in the knee. We're going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone. If this occurs, if this comes in, the state is going to have the opportunity to take lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now,
Owens.
like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5 Diagnostic Statistical Manual, version 5. It's text revision, something like that. What it is and what they describe it as is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder diagnosis. It'll say, well, all agree that it means these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one. Isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into at the end of the day, after we talk about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society. But years ago, when this was first being researched, the question would be, well, why don't you leave? And Battered syndrome, the testimony from experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, returning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspection. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go.
It's not his lapel mic, it's the camera's mic that has its gain turned all the way up. That's why you can hear a lot of other things happening, and that'll drown out what's being played there. It's really annoying. I hate when it happens, but again, remember, it's not for our entertainment, it is to present to the jury. So we can whine, we can cry, we can do whatever we want. We won't get better audio. Sadly, it's this bad, but hopefully they will use the podium to present their evidence. And Shore Life, thank you for gifting 5 Broken Baker memberships to Indigo Luna, Gina L, Dave Atheist Stand, and Kelly Didi. And Zach, Jamie, it's Friday. What are we doing today? Should we venture out beyond the edge of the driveway or just hang out with the cricket and racist dogs?
Yes.
Thank you, Zach.
Option 2.
It's only slightly less annoying than Zach.
You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things that the box on here, Carfax. You want an expert to get reliable information. An expert's opinion is only the information that he or she relies on.
And thank you for the gifted membership, El Presidente Puddletown Esquire. And those went to Watchdog, Penny Williams, Mom of 10, Dennis Heaton, and Mamasaurus Rex. So congratulations. Welcome to the Church of Mo. We're not tax exempt yet, but I'm working on it.
And the Kool-Aid will be blue.
Yeah.
You got to find proper information. You have to check reliability, particularly in circumstances that we discussed. Another thing,
it's state still.
Because there's a bunch of violent nonsense going on between 2 intimate partners, doesn't mean that that's not something that applies. Some people can go home and fight like cats and dogs. That's just their day, and they get over it. They live their life fighting another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say it applies easily. But we'll talk to her about what she relied upon to make that conclusion. We'll talk about some other things.
It'll get better. Don't worry.
But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own 2 eyes and your own 2 ears.
He just called Sarah a horse.
Yeah.
The evidence is going to show that the defendant
Thank you, guys.
killed Mr. Torres because she decided to do so. Not because the evidence would show an objective, reasonable person in her circumstances. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been. I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Oh,
Here, I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Bell. Now, this is going
well, this won't get better then.
obviously today. Not sure, but trying to make arrangements for witnesses to find expert witnesses.
But we can't hear anything, Jess, so it's hard to do bingo. This guy will not get near a microphone. And he's going to spout off.
I will say, if I were a juror, I don't like close talkers. This would be a whole lot too much for me.
Yeah, I hate this. And I can't go anywhere else because they are not using the court's audio. This is the gain on the camera that they have turned up. That's why you can hear the court reporter touching her keyboard more than you can hear him. It's the same when I do this. You will be able to hear everything happening within 10 miles of me. I can't do anything. Court TV can't do anything. Lawn and Crim can't do anything because the lawyers chose not to use a microphone. You just have to bear it out. Well, it can be it's better in your end, but it's the same feed on this camera as it is on Law and Crime. So only if they have they can have some better technology. I can look at it, but sometimes when you go to one of the TV stations, you lose the closed caption. And I know a lot of people want
Baker,
the closed
do your
caption.
job. Make it audio perfect. Don't you have one of those little doodads that Recovery Addict has with all the little buttony things?
Some bruising.
Well, no, they are actually using a different camera. So I retract my statement and I blame Jamie.
You can blame me. I'm audio illiterate. So
Oh, I like to blame Jamie.
Hey,
Let's.
let's give you options.
Oh, I said it's better, but it's not. You can just hear even more shh.
But I know your focus is on this case because you took the notes.
But there's no closed caption on this one.
Ladies and gentlemen, there's no higher call than the right of way. No higher call than the right of way. And we're going to ask you to go to the case without the story.
Of course, Jamie, whatever you say.
how hard would it be for all law schools to just have a mic etiquette class?
With that, critical exam.
How far back
You're
do I
making
have
us
to
listen to
go?
Owens. Dang it. I mean, yes. Let's listen to Owens, get her a fair
And a lot of
trial.
times, eventually, it involved forcible sex with Sarah Boone
What?
or actual physical violence against her.
Well, I can't go all the way back because they don't have more than 8 minutes, but the audio is
Off the
better.
line. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so,
They were
the
crafty.
wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in and going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle. Will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes up.
But didn't he get violent when he get drunk? He comes in with the second bottle and she knows what's up, so she tried to keep him occupied. Now they get silly when they get drunk.
Yeah, here's my problem. If you are genuinely with someone who gets erratic or violent, you tend to not drink. You tend to not partake because you need to be, to use a Sarah Boone word, corpus mentis. You need to be aware. You need to know. You need to know when to flee, as her words are. You do not put yourself in a vulnerable position where you would be drunk and unable to defend yourself if you truly were afraid of this person. I mean, so unless he was pinching her nose and, doing like a dog medicine thing where, he poured the booze down her throat, I don't get this.
It's what the kids call BS.
Upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase.
I don't get that one. Why do you get cold in the shower? It's just as much inside the house.
It?
Yeah, that's what I'm thinking. Is she stupid enough that she turned, because he can find you if you have the water on you, the numb nuts.
Down a week or so ago, it's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they move back and forth. Well, she comes down.
Thank you for the super chat, Zach.
The steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, I can't breathe. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's
no, she's 40 pounds bigger than him.
If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. Physical restraint. And so she lets him have it. Says things she shouldn't say. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes.
Yes.
There's another video that's approximately 11 minutes later. The first video, George's, the suitcase is flipped upside down. The zippers are off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay?
What happened?
I don't know. Is he arguing that in the 11 minutes she didn't film, George attempted to attack her?
Sarah Boone will take the stand.
Woohoo!
She will explain what happened.
Yes.
Nope.
She's going to do a narrative, though.
She will
That's the whole
explain
thing.
why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner.
She has to take the stand because she can't claim battered spouse if she doesn't testify to it. So if she doesn't testify to it, all their experts can't come and say it. There was some ruling made yesterday about that.
She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that, involving that. Her son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loves you. You know, you're going to hear why women don't leave.
This is what they're going for, yes. But unlike the rabid dog, he's not barking, he's pleading.
Yeah.
Why women don't
You can't watch those videos without feeling... If you don't feel she should burn in the hottest pits of hell, you are not a human being.
Yeah, they're just
and you're going to
chilling.
hear about Sarah Boone and her struggles.
The son is roughly 14 years old. He lives with his father because Sarah got depressed when she got a kid and started drinking heavily.
Her mental health struggles.
Addicts do stupid stuff.
Sarah had no intent to kill. Prosecutor mentioned she wanted him to die. Farthest from the truth.
This has already been
She hated the abuse.
ruled that she will do it in narrative.
She tried. She tried kicking him out 6 or 7 times. He kept coming
I know.
back. She changed the locks. He kept coming back. She didn't have the family.
She kept
She didn't
inviting
have
him back.
support.
She
Yeah.
lured him back.
Vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect.
That's going to burn her up.
And
Yeah.
Take her
She's
pen
gonna
away.
objection. Your ownership. Objection.
Yeah, she
I
does.
am perfect.
as many of us do,
Excuse
when we
me.
drink too much, and you sleep in. She slept in.
No, she was drunk. She didn't sleep in. She was drunk. It's different. It's
Yeah. Oh.
voluntary intoxication. It's not like when I've been streaming all week and Sunday mornings I sleep 10 hours. She chose to get hammered and slept in because of that.
And she got up for, at 10, according to her, probably passed out again. And from 11 to 12, she was playing on her phone.
Yeah.
I get he's working with what he has,
Yep.
but relying on Sarah Boone as a reliable narrator is just, it's a fool's errand. And good Lord.
12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase.
Now we have interpretive theater as well.
She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. Where her son is at, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, "I'm coming over. Please come over." He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. She called 911. She calls 911 within a minute or two. Detective Rodriguez arrives. They got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible.
Somehow?
It is a mystery. Call the Hardley boys. They need to get a clue.
Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She just responds.
Dude.
She's the first responder. And, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs.
It's called Cellbrite.
videos, all that. And they find these 2 videos. Sarah's not aware. She doesn't remember making the video. If you can imagine. She
No, I
gives
can't
them the phone.
imagine being so drunk I took a
Well,
snuff
she makes
film.
no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson, is her name. Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. They said, end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant. Can you come to the sheriff's department? Which Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead it was an interrogation, and they were going to arrest her. They made their mind up on it, and they were going to confront her and try to get her to confess based on the 2 videos.
As
And
they
so
should.
There was approximately a 2-hour interrogation that was on the 25th in the afternoon. When she got there to get her phone, they said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped.
Oh, for flip's sake.
It goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to.
She lied?
No, let's be honest. That woman isn't scared 1 second in that video. She's argumentative. She's bitchy. She's looking at Mr. Porn shirt like, you dare talk to me that way? I'll put you in a
Baker,
suitcase.
tell me and we'll both know. That's, I mean, I was so scared and I was doing my best to cooperate and be available and emotionally mature during this. I lost George. She's going to use her little girl voice and I am going to lose my mind.
I can't wait for them to show it so they can see how scared this woman was. She didn't give 2 craps about. She was more concerned that she had to inform George's family, and she wanted to get his wedding ring back because she bought it. I'm sorry. This is stupid.
Pin her on this, that this was some kind of intentional act.
Oh, we're already getting a
And it was not.
for lunch.
So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand.
Then why didn't she ask for one of them
she's
lawyers?
justified in using
Yeah.
the force that she used.
She was told multiple times.
She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that.
I'm getting angry now.
Oh my
So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you and read an instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone would give you. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said,
You can't have
the struggles
unintentional
that
self-defense.
occurred, many of them involve the police. So you're going to actually hear from some of the police officers. maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe, at least a bit. So her attitude is not one of distress. You know, we're here today, full packed courtroom. Judge Graydon's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the
He's
law.
not lying. He's just telling
We
his truth.
talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case.
Nah. Nope.
But the most important thing
Don't think. No.
is not to rush to judgment, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed
Thank you for
opinions.
explaining why they have two tables.
That's hard to do, as Mr. Henderson said in open or in jury selection. That's
I really
extremely
can't
hard to
imagine
do.
what an untainted juror would be thinking right now. Beckelin, that's
Now,
yeah,
you're going to
that's
hear some testimony. There's been mention of experts.
I did that with
Battered
Valhalla,
women's
and I still pay for it.
experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not.
Yes, it's 3 weeks with jury selections, is what they said.
After hearing both sides of this case, we're confident you're going to have a reasonable doubt.
Even the stream couldn't deal with him.
And do justice in this case. And find Sarah Boone not guilty. Because it's the right thing to do. Thank you.
Thank you, sir.
I'm going to jump. They're going to go at a sidebar, and we have the first witness.
Sir, good morning. You could be seated. And once seated, if you could state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
Six or seven.
And how?
I'm just saying it. If you have to count and say 6 or 7, either mom or dad was a horn dog. If
I
you're
mean,
not sure
to
if
be
you have 6,
fair, there's a
I
lot
think
floating out there.
I'm pretty sure I know how many siblings I have.
Okay.
Well, you can't. You
Well,
can't say that with Mo on the panel right now. Come on.
yeah.
I bet you each and every kid in the Mo's household know how many kids are in the Mo household.
To be fair, I never call them the right name. So they're like, I am not so and so. And I'm like, well, I'm yelling at you and I'm looking at you. So get over here.
I like that. Yeah, there might be a brother out in the shed somewhere. I don't know. 7?
But honestly,
long
my
has your-
husband won't remember anything like dates or, Mother's Day being a regular occurrence every year, that kind of thing. So maybe it's a guy thing.
No,
It
I
is.
remember how many siblings and kids I have and how many marriages. I can remember that, but I can't remember birthdays.
Those are hard.
family resided here in the Central Florida area.
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I'd say, on a weekly basis.
And how far away did you live?
Helen from Holland, we are roughly 15 minutes away from lunch break, and I would have to switch again. I'll do it after lunch. I'll find the one with the closed caption.
From George?
About 5-10 minutes, pretty close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Wait, Sarah?
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
Just
I don't have a
we
closed
just
caption.
talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just talked.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
This is the brother testifying that
I
the last
really
conversation
hope-
he could hear Sarah yelling something about choking in the background.
The defense needs to play it really, really gentle with him, because I'm glad that this particular lawyer is doing it, because I think Owens would come off as very aggressive.
Good morning, sir.
Yeah.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother Jorge Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
Just so we can get the closed caption on. Now I just hope the audio works.
Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother Jorge Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean,
Okay.
not you, but any of your other siblings?
No.
Let's see if we can do it at 1.5 because he's a slow
Let's go
talker.
back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Yes, sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
And this is kind of normal. I think his
said
deposition
you heard
did
Sarah.
say,
Yes, sir.
Is that correct?
Yeah, he was sounded
How did you know
drunk.
it was Sarah?
yeah.
I can tell her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right.
Could hear the sounds of
You've
the
heard Sarah speak before
damn souls
before that
coming
time.
out of her
Is that
mouth.
correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct? And you said that Sarah was yelling. Is that correct, sir?
Yes, sir.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No. Sir, at some point, your brother said he had to go. Is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have. If I can.
You may, sir.
Well, you are right, Mo. They did what they should to not be attacking him.
Yeah, and I think the state also, it was pointed out in chat that he looks a lot like George, so there's no way
Sure,
that
other than,
Sarah's not seeing that.
Siblings. Your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
It says paralegals or helpers, whatever it's called.
Any redirect examination?
No, Your Honor.
This witness be released.
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
In Jamro.
Sir, good morning. You can take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
What is this witchcraft that makes me able to hear his voice?
It's magic.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for public supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently at a Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as states D and been shown to defense?
D's and Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as states D. Could you use these scissors and open
Yes.
and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do, yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time I'd like to move what previously been marked for identification as states D into evidence.
Any objections?
No objection.
What was pre-marked as states D will be received into evidence without objection to states 1.
He went to the barber right before this. He's got a nice line.
Yeah.
Of course, it's going to be on national TV.
He knows that
You may.
millions of people will be watching this.
So I'm showing you it's been marked for identification as states J. Can you take a look at that disc?
Now, my brother is in Ohio as a cop.
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
Mouth to God, yes.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification, the state's J, into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
Were we going to get a video of her buying the wine?
Any cross-examination?
Or was it
It's
George?
also released.
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day.
Oh, that's all. Ciao.
They
So
just
nice
got
to
to get in the
meet you.
video and the receipts.
Stay. Ma'am, good morning. Could you state and spell your name for the record for us?
It's not morning.
Okay, Joan,
Lunch.
Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office.
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical. We try to transfer to the medical side of the business.
And is it the regular practice of Orange County to record?
In the box, there's probably a baseball bat and a suitcase, and I don't know what the last did. Maybe the dog they were dancing with.
911 calls.
All lines are recorded.
Oh.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
May.
Identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into
I haven't seen
Any
that.
objections?
Also,
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Thank you, ma'am.
I like they're going quickly and efficiently.
yeah, just laying foundation so they can play it all later with the cops.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Good morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one room.
Drunky the bear can come in now. No, that's the building manager. This is the neighbor. The guy who said that he heard a lot of noise.
I like his
Brandon.
polo or his button down. Are those
It's a
airplanes
shirt.
or
It's a shirt with I think birds on it, and get a bigger shirt when you have moobs. You always go with size up when you
I
have
am a bit distracted by his cleavage, not gonna lie, but I'm a 12-year-old at heart, so anything will make me giggle.
Yeah, that was it.
That's Brandon Motes. Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and Jorge Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
Yeah, the 20-year-old.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time?
It was pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Not on
Did
the
she
desk.
make any motions with her hands?
Yeah, like just kind of like, you know, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there.
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake. It stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
He
Did you
means
hear any
cam
yelling
model.
coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like.
I said there's no premeditation as she's not charged with murder one.
Like
I try to keep it off when I'm chewing my Oreos.
Whatever it is, whatever the argument was about, kind of thing. At the time, that's really all it was. But it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah. All the time. It was like a back and forth.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, you know. Then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment. So it was like, there's like a little kick out next to my patio, and that's like, that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Mr. Pagley, good morning. Now, you said that you lived there next to Sarah Boone and George Torres for about a year?
Yes, sir.
Are you aware that the police were called to their residence?
Like
while you were there for the year, are you aware of any incident in which the
Like
police
for
were
the
called to their
suitcase
residence?
thing?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why
Just instead of what somebody else told you.
Yeah.
Just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Class at 1
Do you
o'clock in
have
the
an
morning?
opinion
What
as
were
to
you
whether or
going to
not,
school
based on
for?
your interaction with Sarah Boone?
Let me finish the question first, please.
This is that weird college in Florida that all Casey
You know,
Anthony's like boyfriends
From
went
your
to.
experience with Sarah Boone and your experience with George Torres, that they drank alcohol?
Yeah.
Hang on.
It was open like 24 hours.
Thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Yes, of course.
Yeah, there's no denying both of them were drunks.
Yes, I know. I stopped hitting you for 1 second to try to type something. How dare I?
Vincent, I think you had testified, you may have given a statement to law enforcement.
Yes, it was one of the
you're getting
detectives.
too big
A recorded
for the
statement?
boob shelf.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object this to improper impeachment.
approach. Around 7. Sir, would it be fair to say on that date you got home around 7? 7 p.m.
7 p.m.?
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon. Because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could
Once
hear
you called
started.
Brian, or just
No other
before?
questions?
Just before.
Can this witness be
Brian.
released?
Yes, John.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.
There's a lot of sidebars.
Yeah, I don't understand why they're keeping him subject to recall. He doesn't really know much.
No,
Bless you.
that guy with the allergies, he really should. I don't know. Are they going to 1 o'clock? I've set the afternoon stream up for 1 o'clock.
Might be.
Thanks, sir. You can be seated. State and
this
spell
is
your
the
name for the
part that
record.
his
for us.
wings got cold.
Yeah, my name is Brandon Moats, BrandonMoat.
Have you ever? Do you get that where you see a face and the voice just doesn't fit that face?
I'm just.
His face doesn't sound. Doesn't look like his words sound.
No.
I love that he's like, oh, I have a wrinkled button down. This is going to work. I'll spray some lemon pledge on it. Not going to brush my hair. She's just like, I am court ready. What in the world?
Yes.
Thank you. Mr. Castro, you may inquire.
I think it's the same
good
guy
afternoon,
speaking all
sir.
the time.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021.
Yes.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you live, tell us
Obviously.
Keep this witness, Owens.
separated.
So, yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment. So they had a staircase running right next to the walls, next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you'd definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
It was the background of his life.
Do you recall the evening of February 23rd?
I can't sleep. Can we turn on the drunken lady noise?
Yeah.
And on that evening,
it's
could you
white
hear
noise
arguing
now.
going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock. That evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would it have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a one-story apartment, and then they next door had like a 2-story townhouse. So we only had the one floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us?
Always blame the expert.
I mean, yeah, literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above.
She said a bottle of wine and the rest of the bottle from the day before was what they shared.
Of my ceiling, and it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me, like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate. I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, yeah. I never saw her after that happened.
No further questions.
Any cross-examination?
Are they gonna go there and say it was Torres throwing Sarah down the stairs?
Probably.
And
Good one.
Fought him with a suitcase.
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or Jorge Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah. I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Do you remember this interaction?
Hey, let's run straight into this wall and have a very credible witness say they were drunk all the time.
Yeah.
Why don't we just
Sarah
introduce
Boone.
Drunky Bear as evidence? Off of Cheetos,
Give-
this defense is ridiculous.
Give her a bear suit. She can sit in court
I looked for
with
one
a
at
sash
Walmart.
saying "Drunky Bear."
I may or may not be looking at Amazon right now. Mr. Mo is gonna have words with me.
Oh, I thought he was going to be dressed up as Drunky Bear, and number 8 was
Hey,
on the way.
what I do on Wednesday nights for date night is completely up to me.
Are you gonna wear those eyebrows for sexy time? That's what I would do.
I might. This afternoon section, I am still a very weird child. It came with a handlebar mustache. We might be doing that just so I can go, that makes perfect. I will not be picking up my kids like this, though, because I don't need a mental health evaluation against my will this weekend.
In 2009, when you woke up and witnessed Sarah,
I would have been 9 years old in 2009.
I'm sorry, 2019. Catch. In 2019, when you woke up and witnessed Sarah sleeping on
such idiots.
Concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school, and she was trying to talk to you, and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying because I didn't want to talk to her. She just
He's like, get away from me, devil woman.
Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go
he
home.
said vibe. Never mind.
Yeah.
He's voted off the island.
I believe, and I just want to make sure I heard you. You said that the first arguments, other than the boom, which was like 10 something, initially it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5 because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after I took, because I came home, I made myself lunch and I took a shower, and then I heard all of their arguing, so it would have been about an hour and a half, 2 hours after I got home, so around
Lunch at
7
5
to 8
o'clock.
And
Did you also wake up at the crack of noon?
Back and forth.
Is that a
honestly, I
Florida
wouldn't really
thing?
be able to say if it was back and forth. I don't know too I wouldn't remember too vividly if it was back and forth.
Well, let me ask you this: if you hear a male voice,
Has been no evidence provided of anything other than alcohol.
Yes, I heard a male voice.
did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
Okay.
Here comes the Boone. Booney.
If I can confirm, Judge.
Yes, sir, of course.
It's hard to sing the McMahon song for that one. Here comes the money.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall.
All right, sir, you're released subject to recall. Thank you.
Why do they want them back to talk about how drunk she was all the time? Just because there was
Parties approach.
I
There
think
was
they're
two-sided
doing the
yelling.
spaghetti on the wall thing. So in case they, Sarah changes her testimony and then says, I was super scared and I was trying to tell him and get some
Important
help.
process.
And
It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days.
So 2 p.m.
Sirs, you must not
is
conduct
gonna
any
be-
investigations
that's
on
good.
your
I'm
own.
gonna go
This includes reading newspapers,
take Molly
watching
out.
television, or using a computer, cell phone, the
And I
internet,
have
any
stream
electronic
set up
device,
2
or any
p.m.
other means at all to get information related to this case or the people and places involved in this case. This applies during the trials. Must see you at 2 o'clock, and I thank you for your service.
Let's see if there's anything after the jury leaves, or else I will redirect you all to my afternoon stream. Mo will redirect you to her afternoon stream. We'll be back a little before 2. Mo will be kind of dubious sexual with a goatee, probably. Well, a lot of us guys will sit here and think about our sexuality.
It will be confusing for everyone. I will try not to break out in YMCA or, in the Navy, but it's going to be a difficult, thing to do.
Yeah, that could be why, Sarah, that they want to. But again, it's...
State, anything we need to address? Events. All right,
Is that an hour and a half?
Couple
Yes.
inquiries of you, ma'am, before release.
If you're in
Satisfied
Europe,
with your attorneys
8
so
o'clock
far
main.
throughout this trial? And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock.
Do they have to keep asking her that, like, every time?
I think he just does it to keep, because he knows he's going to get angry letters. If you're in Britain, it'll be 7 o'clock. In mainland, it'll be 8 o'clock. Eastern Standard Time, it'll be 2 o'clock. Then I don't know the next time zone or the next time zone. West Coast, it'll be 11 o'clock.
Banana
o'clock. Central, banana split o'clock. Mountain Time, no one uses it. It's weird. Benjamin Franklin should have never invented it when he was the first and best president of the United States. I have heard it asked when the trial is done, are you satisfied with the way blah, blah, blah. I've never heard them ask at the first recess. In Finland, it'll be 9 p.m. or 2100.
He asked her, like, before they started trial, too. He's been doing it periodically.
Paulson, what you're supposed to do until then, go make yourself a peanut butter banana sandwich. Sing Blue Moon of Kentucky, keep on shining, shine on. And come back and be ready to do it with us again at 2 o'clock. Because I need to take poor little Molly out. I need to get some dinner. Jamie needs to go save the hairless mole.
Yes.
It's an endangered species, lives in North Africa. Kind of looks like a peen with teeth. But it's important for the eco-environment where it lives. What time in Jamie's standard time zone? 5 minutes after. That's why she normally shows up.
I show up when I show up. You be happy.
She is Gandalf. She arrives when she is supposed to.
7 a.m. New Zealand time.
Ooh. You're just starting your day.
I haven't had a cigar in a long time. I really can't figure out how to smoke cigars. On that note, about my ineptitude of cigar smoking, hasta la taco. See y'all later. Bye.
Okay, bye, guys.
Bye, guys.
Bye.
Exhibit are you referring to? I'm going to make this 100, Your Honor. All right, 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
Go
All right, I'm in love.
back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.